The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to council and to all of those watching us on our Supreme Court Live channel. At this time, I'll ask Mr. Doug Shima to please call the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Thursday, May 19th, 2022 consists of two cases. First case to be heard on the docket is appeal number 124812 in the matter of Gary W. Long II, original action and attorney discipline. Immediately following, the second case will be appeal number 124867 in the matter of Joseph R. Borich III, original action and attorney discipline. Your Honor, the appellant in the matter of Gary W. Long 124812 has reserved 2 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office.
May it please the court, Gary Long appears in person by video with his attorney Trey Petlin.
Thank you, counsel. Mr. Vogelsberg, you may begin.
Thank you, Madam Chief Justice. This is an original action in attorney discipline involving respondent Gary W. Long II. Mr. Long was admitted to the Kansas bar in 1988. In 1998, Mr. Long was disbarred after he had surrendered his law license while a disciplinary case was pending against him. Subsequently, Mr. Long's law license was reinstated in September of 2015. The current disciplinary case against Mr. Long involves 3 separate disciplinary complaints. The conduct at issue here began approximately 4 years after Mr. Long's reinstatement. In the first case, DA 13312, Mr. Long was retained in February 2018 by client LJ to bring a quiet title action and to cancel a contract for deed. LJ advanced funds to respondent, which he deposited directly into his operating account rather than his trust account. He failed to diligently pursue the matter for LJ, failed to respond to messages from LJ asking for updates regarding her case, and falsely told LJ that he had gotten a continuance of a hearing. Respondent also failed to cooperate in the subsequent investigation of the disciplinary complaint that LJ filed against him. In the second complaint, DA 13519, DH, an inmate at the El Dorado Correctional Facility, contacted Mr. Long in March of 2019 to represent him on a motion to correct a legal sentence. Mr. Long quoted DH a fee of $1,000 and told DH that he would not begin working on the matter until his fee was paid in full. DH advanced Mr. Long $800 of the $1,000 fee. Mr. Long deposited these funds into his operating account rather than his trust account. DH eventually filed a complaint with the ODA. Upon receiving the complaint, Mr. Long refunded the money to DH and provided a written response to the ODA. Mr. Long, however, failed to respond to subsequent requests for information from the assigned investigator. Finally, the third complaint, DA 13626, concerns Mr. Long's representation of CN in an expungement matter. In February of 2019, CN advanced $2,000 to Mr. Long, who again deposited these funds into his operating account rather than his trust account. Mr. Long failed to diligently pursue the matter or to adequately communicate with CN. CN filed a disciplinary complaint on January 11th, 2021. After receiving the complaint, it took Mr. Long until March 8th, 2021 to file the expungement petitions in district court. The petitions were ultimately granted by the district court. It should also be noted that the delay in getting the petitions filed in district court occurred after Mr. Long had instituted his initial probation plan. These complaints proceeded to a hearing before a panel of the Board for the Discipline of Attorneys on August 12th, 2021. At the hearing, the Disciplinary Administrator's Office recommended that Mr. Long's license be suspended for a period of 1 year and that he required to undergo a reinstatement hearing under Rule 232. Mr. Long asked to be placed on probation. Thereafter, on January 28th, 2022, the panel issued its final hearing report concluding that Mr. Long violated KRPC 1.3 diligence, 1.4 communication, 1.15 safekeeping property, 8.4D conduct prejudicial to the administration of justice, and 8.1 and former Rule 207B relating to his failure to cooperate in an investigation of the disciplinary complaints filed against him. Regarding the sanction, the hearing panel concluded that placing Mr. Long on probation was not appropriate given his record of discipline. The panel also found that the respondent had failed to put all the provisions of his probation plan in place prior to the disciplinary hearing as required by Rule 227, and that his plan did not contain any provisions to address his trust account issues or to address his struggles with depression. Consequently, the hearing panel adopted the recommendation of the ODA and recommended that Mr. Long be suspended for 1 year and that it be required to undergo a reinstatement hearing. The hearing panel report was filed with the appellate clerk's office on February 14th, 2022. Thereafter, on March 8th, Mr. Long filed his statement pursuant to Rule 228 that he was not taking exceptions to the hearing panel's findings of fact or conclusions of law. Accordingly, the only issue that's before the court today is determining the appropriate sanction to impose in this matter. Mr. Long is asking this court to place him on probation. Prior to today's hearing, Mr. Long submitted an affidavit to the court pursuant to Rule 227F, noting his compliance with the probation plan, which he supplemented with additional conditions on March 15th, 2022. The ODA is still recommending that Mr. Long's law license be suspended for 1 year and that he undergo a reinstatement hearing. The ODA believes this recommendation is appropriate for 2 reasons. First, Mr. Long has an extensive disciplinary history for conduct that is substantially similar to the conduct at issue now. As I mentioned before, Mr. Long was admitted to the bar in 1988. In 1992, he received an informal admonition for failing to diligently pursue a discrimination action on behalf of a client. In 1994, this court placed Mr. Long on supervised probation for 2 years for violating 1.1 competence, 1.3 diligence, 1.4 communication, 3.2 expediting litigation, and Rule 207 cooperation in a disciplinary investigation. In 1997, a hearing panel recommended that Mr. Long be suspended for 1 year for violating 1.1, 1.3, 1.4, 3.2, and 8.4A professional misconduct. Before this court could consider the final hearing report, Mr. Long surrendered his license, resulting in this court disbarring Mr. Long in March of 1998. As mentioned before, Mr. Long was reinstated in 2015, despite being.
I'm going to jump in with my question here.
Okay.
Do you know, is this the first time we have considered a disciplinary matter of an attorney who had previously been disbarred?
I know that
we haven't reinstated that many. I don't know the number off the top of my head, but I bet I
believe, including Mr. Long, I think there's been a total of 3 attorneys who have been reinstated since disbarment.
So this would likely be the first instance of a disciplinary action, reaching us at least, of one of those 3 attorneys who's been reinstated. Do you think that's right?
I believe that's right, to the best of my knowledge.
And should that unique factor play a role here? And I'll I guess indicate that I think it probably should. I'm not certain that the panel really, or even your office, has considered that.
The only time I'm considering it is obviously in my argument against probation, believing that because of the disciplinary history, which includes a prior disbarment.
Just sort of cutting to the chase. I'm wondering what in your mind justifies even only a 1 year suspension when counsel had previously been disbarred for similar violations. It's just a sort of one of those, how many chances does someone get kind of question.
Right. In Mr. Long's defense, when the discipline that he was facing prior to surrendering his law license that ended up in a disbarment was a 1 year suspension. I believe the panel also recommended a reinstatement hearing. And so for whatever reason, instead of coming to the court and probably likely facing a similar sanction, he went ahead and surrendered his law license. Coming forward and dealing with the conduct at issue here, I don't believe that if you just looked at this conduct in isolation, that it would rise to the level of a disbarment. And so that's why I still think, despite his prior disbarment, why I think a 1-year suspension with a reinstatement
Okay.
hearing is
So
appropriate.
your answer to the question would be that we should consider this as we would for other attorneys and not sort of impose a heightened standard because this attorney had been disbarred and then reinstated.
Correct. And the prior disbarment really was not for conduct that would have resulted in a disbarment based on this prior decisions of this court. Now, kind of addressing Justice Stiegel's question, despite being given a second chance, Mr. Long has continued to engage in the same type of conduct that he engaged prior to being disbarred. And so accordingly, the ODA does not believe placing Mr. Long on probation is in the best interest of the legal profession or the public. Now, the second reason that the ODA does not believe he should be placed on probation is that we don't believe probation will provide adequate safeguards to ensure Mr. Long's continued compliance with the rules. As I mentioned before, Mr. Long implemented his initial probation plan on January 5th of 2021. The ODA received the last complaint that is before you today on, which is DA 13626 on January 11th, 2021. After receiving this complaint, it took Mr. Long until March 8th, 2021 to file the expungement petitions in district court and to also file a response to that complaint that we received. ODA believes that Mr. Long's delay in getting the petitions filed and responding to the complaint while he was implementing his initial probation plan indicates to us that probation will not provide an adequate safeguard and should not be imposed here. In conclusion, I would respectfully ask this court to affirm the findings of the hearing panel and its conclusions of law and impose a sanction that was recommended by both the ODA and the hearing panel, a 1-year suspension with a reinstatement hearing.
One point.
Unless
Yeah, one clear, I want one point of clarification. And I don't know that it's a part of the record or that you can cite to it. But in 1997, when he surrendered his license and was disbarred, and you said the disciplinary action was pending, were there any other disciplinary complaints that were pending at the time he was disbarred? I mean, in other words, he had the case that was before us, but were there any other, that happens frequently where other cases come in. Was that the situation here, or do you know, or can we even factor that in?
I believe there were 2 other disciplinary complaints that were pending that had not been before the hearing panel when Mr. Long surrendered his license. I would cite Exhibit 30, which would be contained in volume 3 of the record, which is the court's order of disbarment, which I believe notes those 2 other pending complaints.
And do you know what those involved?
Off the top of my head, I do not.
Okay, that's fine, Mr.
I'm sorry.
Vogel. I appreciate the direction that you can point us to. Thank you.
Unless any other members of the court have questions for me, I would waive the remainder of my time and address the court again during my rebuttal.
I see no other questions. Thank you, Mr. Vogelsberg.
Thank you.
Mr. Petlin?
Chief Justice Lukert, justices of the Supreme Court, we understand that we're here before this court on recurring issues involving communication and diligence and trust-related issues, trust account-related issues. These issues, if you examine them in the context of the evidence that was presented and the exhibits, the numerous exhibits, are difficult to explain. My client's inaction is difficult to explain because it oftentimes involves very simple tasks. We have 3 complainants before the court today. Mr. Long had petitions for expungements prepared, signed, and ready to go and simply didn't file them for several months. Mr. Long had grounds for a default judgment for his client. He was given additional time to get the motion on file and did not file it on time. It was delayed. It's not a matter of capability. We know that because when LJ filed her complaint, my client got the default judgment done fairly quickly. His case also presents the quintessential example of rule violations pertaining to communication occurring with rule violations related to diligence. When he made no progress in tasks in LJ's case and in CN's cases, his communication fell off. The inertia toward accomplishing the tasks and returning correspondence in these two cases is evident, and my client stipulated to that for the panel hearing. A lack of timely cooperation with the Office of the Disciplinary Administrator with the it doesn't make any sense. You know, once again, when he didn't reply to the disciplinary administrator's letters of complaint, he was given additional time to do that, and he didn't. And in the LJ matter, he worked on his client's case to resolve the issues. At the same time, he wasn't responding to the Office of the Disciplinary Administrator. And ultimately, he admitted all of those facts. The recurring issues related to not using his trust account are also difficult to explain. He violated 1.15 by depositing unearned fees in his operating account. And as Mr. Hazlitt indicated during the panel hearing, he had a fundamental misunderstanding of N. Ray Thurston, the 2016 case. That doesn't explain all of it, but that was certainly pointed out. And my client has since read N. Ray Thurston, and he's understanding the rules related to flat fees. But again, it doesn't explain it because he clearly did not intend to deprive his clients of their money. He documented payments with correspondence, for example, to DH. And ultimately, there's not a single instance where a client lost their fee they paid as a result of a violation of 1.15. Now, all of this leads to the one mitigating factor that I think is a very notable mitigating factor that the hearing panel found related to my client's mental status, his depression. I once appeared in front of a judge that I admire very much in a criminal case, and other people were alluding to the fact that my client the probation officer described my client on the record as lazy. And I said, my client's not lazy, Judge. My client is depressed. He's seemingly overwhelmed by tasks that seem simple to most people. And the judge said, I'll never forget it. He looked at my client. He said, Mr. So-and-so, look around you. We're all depressed. And I understood the point that he was making. It's not an excuse. Everybody's dealing with difficult things in their lives, and lawyers have to rise above that. They have to find a way to deal with their own personal tragedy, their own personal difficulties, and still represent their clients responsibly and diligently. And my client didn't do that. The judge, Justice Biles.
Yeah, I mean, let me tell you, I'm having a little trouble with getting access to the record on the internet, so that's why I'm asking this question. The hearing panel report in the discussion of the respondents' depression and anxiety issues, which would be, you know, in my experience, a common explanation for why we have the misconduct that we have. I can't get access to the Exhibit A and B. Do you remember what those were?
Both of them were letters from my client's counselor.
Okay.
And the second one just simply elaborated on the first one with a little bit more clarity. I understand that's a common thing. Of course, depression is very common, and our industry is very difficult. There's a lot of stress. There's a lot of anxiety. And when you don't accomplish tasks and you become more overwhelmed, you don't just stress out your client, cause anxiety because you're not returning their phone calls. You also increase your own anxiety by not simply calling to say that there's no progress in the case or that there's no new news. I love a quote by Jim Carrey who said, I believe depression is legitimate, but I also believe that if you don't exercise and you don't eat a nutritious food and get sunlight, get enough sleep, consume positive material, surround yourself with support, then you aren't giving yourself a chance. And that's true in the KLAP involvement that Mr. Hazlitt was instrumental in my client getting involved with, dealt with a lot of those issues. He began that in 2019, I believe. The period of the violations were from February of 2018 to April 28 of 2021. From the time that he was retained by LJ to when the 4 expungement petitions were granted for CN. And the evidence seems clear that during this period of time, my client had significant loss in his life that he was struggling to deal with. The loss of his wife, who died from cancer in April of 2017. And he testified at the hearing that that was devastating for him, but he didn't appreciate how devastating it was. He didn't begin his counseling to address his grief until the end of 2019. And even then he started to see a counselor, but he wasn't seeing her enough. During the panel hearing, Mr. Hazlitt referenced my client's younger brother who died in 2021. Now, he had a 2-year battle with leukemia. So all of this is after my client's been reinstated. He's gone out, he's basically, after 17 years, he's reinstated. So he's sort of starting new because the world has changed in that time. And he is a solo practitioner at that time. He doesn't have the mentorship he certainly needs. And he is coping with significant depression issues. The panel noted that the probation was not supported in paragraph 72 of their opinion, in part because his plan was not substantial and detailed enough to address the recurring issues, most notably the trust account issue. And it didn't address the significant mitigating factor that he had, his depression. So after some correspondence and some discussion with Mr. Hazlitt and Mr. Vogelsberg, I submitted a amended probation on his behalf. He represented himself pro se at the panel hearing, which obviously wasn't an intelligent thing to do, but he went in and just fell on the sword, and he had been involved in KLAP, but he certainly didn't present a detailed probation. So we did that with our 227 affidavit, which involves more detail, more oversight, and which surrounded him with support. His probation makes the recurring issues a focus in his practice, dealing with his grief and depression responsibly, meeting his counselor who specializes in grief counseling. That was increased to bi-weekly. As the affidavit materials reflect, he's participated in KLAP's resiliency group almost without fail. That's bi-weekly, not required by his KLAP agreement, but he's doing that. His attendance has been excellent. That's been helpful. His practice supervisor now has access to all his counseling records and has now been charged to monitor his participation in his support that he has in place, and to monitor his files to make sure that these issues don't recur or affect his clients. He also engages in monthly community service work through Harvesters, serving on a church executive committee every week. Combined with effective counseling, that can help with depression. Mark Twain said the best way to cheer yourself up is to try to cheer somebody else up. But not only is it a way to address depression, but it's a way to give back to the community to make up for the injury that he caused his clients here. The probation provides significant mentoring support. He came back, as I said, to a different landscape. Now he's meeting with his practice supervisor once a week. His practice supervisor has a copy of the complaints, has a copy of the panel hearing report, and will have ultimately the copy of this court's opinion. He has frequent contact with his KLAP monitor, as described in the affidavit. His probation requires him to return correspondence within 2 business days, to return correspondence when no progress is made in a case, which I think a lot of lawyers have a problem with. He just recently completed his extra CLE that is required in his probation, and that proof has been submitted to Mr. Vogelsberg. That includes avoiding bar complaints through better communication. That's a linchpin. And the reality is that good communication not only helps the clients, but potentially obviates other issues that may develop in the case. He's certainly not taking any more cases where it may be difficult to communicate with the client because the client is in custody 2.5 hours away. His probation also addressed the trust issues. His practice supervisor is taking a more active role in auditing his files, his deadlines, monitoring his trust account. His practice software now, as a result of these complaints, deposits all payments in his trust account. He attended 4 hours of CLE devoted to trust account issues, which he completed, and he's using fee agreements in all cases except for simple traffic tickets. And in those cases, he is documenting with email correspondence the terms. So in sum, we understand that there's a lot of recurring issues, and the court has to be convinced that those issues are being addressed successfully. I'm urging the court to consider a 3-year suspension, but staying that on the condition that he complete the 24-month rigorous probation we put in place, stiffer suspension, staying. If he completes that, obviously he will have addressed these issues. In the alternative, that the court is not inclined to do that, I'd ask the court to consider a 90-day suspension followed by the 24-month probation that we have submitted. He will have tremendous momentum. My client would like to address the court as well.
Thank you.
Mr. Long, you may proceed. Sorry.
Thank you, Chief Justice Lukert, members of the Supreme Court. I'd like to take this opportunity to thank this court for giving me an opportunity in reinstating my license in 2015. I became an attorney and asked for reinstatement of my license because I want to help people. A lot of my clients need help. Some of them just need some guidance. And I thank this court for giving me that opportunity. I'm thankful that Stan Hazlitt called me on a winter day and asked me what was wrong and asked me if I was depressed, because he could see from where his side of the equation that I was likely depressed. And I'm thankful that he referred me to KLAP, who then provided me mentorship in KLAP and ongoing support services. And it triggered my recognition of the problem that I needed to address, which I didn't. I was in denial. I'm thankful for my practice supervisor, who does meet with me every week and reviews my files and helps me by saying, oh, this one needs to move up the list and become more of a priority. I'm also thankful for Trey Petlin, who has given me some solid advice and mentorship as far as things I need to change about how I engage with clients, as in learning to say no more. Your case is very important, but I'm not the right lawyer for your case. And Trey and Joe have both been very helpful in helping me be able to tell those clients no. I am asking the court to give me an opportunity on probation. I believe our plan addresses these issues and eliminates concerns, and has checks in place to make sure that if complied with, the probation addresses those concerns.
Thank you. Anything else, Mr. Petlin?
No, Chief Justice Lukert, thank you.
Or any questions from the court? Mr. Vogelsberg?
I would just say that if Mr. Long was coming before this court with a blank slate and that this was his first disciplinary issues, then I would be in full support of putting him on probation. But the fact of the matter is that throughout his entire legal career, he's had same recurring issues with diligence and communication issues. And then here recently, the 1.15 issues with trust, those weren't present in the prior discipline. Those are new issues that have come to light. But with that being said, because of the extensive disciplinary history that he's had, I do not believe probation is appropriate. So again, I would recommend to the court imposing a 1-year suspension with a reinstatement hearing. Thank you very much.
Any questions for Mr. Vogelsberg? Thank you to all of you for your arguments and statements this morning. The court will take this matter under advisement. With that, I'll thank the counsel in this case, and we'll have a short break in the proceedings while we transition to the second case on the 11 o'clock docket. So thank you, counsel.
Thank you, everyone.
Mr. Shima, would you please call the second case on the 11 o'clock docket?
Thank you, Your Honor.
I'm starting.
Thank you, Your Honor. May it please the court. The second case on the docket for 11 a.m., May 19th, 2022. Appeal number 124867 in the matter of Joseph R. Borich III, original action and attorney discipline. Your Honor, the Office of the Disciplinary Administrator has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Tom Stratton for the Office of Disciplinary Administrator.
May it please the court. The respondent appears in person by John Ambrosio. We are ready for argument.
Mr. Stratton, you may begin.
Thank you. Respondent represented the complainants CD and JD in claims against the builder of their home. Engineering analyses showed the home had extraordinarily extensive problems. The purchase price of the home was either a little below or a little above $300,000, depending on whether you count upgrades. A series of repair estimates from Dixon Construction in Kansas City show the cost of a full repair of the home grew from $242,000 in 2009 to $388,000 in 2015. The findings of facts in the final hearing report, to which no exceptions have been taken, establish the following. In December 2007, a contingent fee agreement was entered into between the parties. In late 2008, that fee agreement was revised by Exhibit 4 to incorporate a requirement for repayments to respondent by the complainants, chiefly $500 monthly attorney fee payments. It was agreed that if there was an award, the fees would be deducted as a credit from that award. The agreement says that no attorney fees would be returned if there were no recovery. The complainants testified to their confusion on that point. The revision to the fee agreement does not say the method by which the respondent's fee in the case would be determined. It does not say when the amounts paid by the complainants would be earned. However, and significant to this discussion, it does say that respondent would not seek any additional fees. As I prepared for today, I realized neither fee agreement advises the clients of their right to have the fee reviewed by the appropriate court having jurisdiction of the matter, which shall determine whether the contract is unreasonable, and that's pursuant to KRPC 1.5E as required by 1.5D. Complainants paid $46,910 to respondent. That amount included a total of $5,500 demanded by respondent that was on top of the payments required by Exhibit 4. Those demands for payment were made despite respondent's agreement that he would not do exactly what he did, that he would not seek additional fees. Respondent did not place the payments in his trust account. He provided no accounting for the money. He didn't maintain time records. He provided no billing statements. At one point, he communicated to complainants that his timesheets showed the amount of time spent in the matter was almost incalculable. He later admitted there were no contemporaneously created time records. He said he did not place the payments into trust because he'd already earned the fees before they were paid, but that assertion was determined to not be supported by the evidence. Respondent became overwhelmed by the case. He recommended that complainants hire another attorney, Jim Jackson, to assist. At the time he was hired, Mr. Jackson was to assist respondent with a pleading. In time, Mr. Jackson charged complainants $48,803 for his work, which they paid. The respondent's representation lasted over 10 years. During that time, he accepted assistance from complainants in the case that would ordinarily be expected to be provided by a lawyer or the lawyer's staff. The collective efforts of the parties to this complaint and Mr. Jackson did not result in any recovery at all. Exhibit 17 is an August 18, 2017 Court of Appeals decision. It clearly explains the missteps taken by respondent on this path to no recovery. After the representation terminated, respondent issued a $3,500 check to complainants from his trust account in payment of an arbitration award. There was no arbitration award. The check was funded by a deposit to trust made by respondent out of his personal funds 8 days earlier. The panel found a number of violations of the Kansas Rules of Professional Conduct. 1.1 competence. Respondent failed to timely and properly file appeals. He filed deficient pleadings. He accepted legal and litigation support assistance from his clients. 1.2 scope of representation. He recommended that Mr. Jackson be hired at the client's own additional costs to assist in the litigation he had agreed to undertake without first properly consulting with his clients. Also referred to as the assistance provided by the clients beyond that which could be reasonably expected under 1.2. KRPC 1.5 A and D fees. The Exhibit 4 amendment to the contingent fee agreement was unreasonable and failed to comply with the requirements for a contingent fee agreement by failing to specify in what event the amounts paid by the clients would be regarded as earned, resulting in the client's confusion about the way he treated the monthly payments. The agreement was also deficient because it did not state the amount that would accrue to respondent. The payments were not placed in trust, were not coupled with billing statements or an accounting, were not refunded when there was no recovery. 1.5 A, B, and D, safekeeping property. The underpinning for all of the 1.15 violations is the failure to deposit the payments into trust. Respondent's explanation that the fees were already earned was not supported by the evidence. 1.16 A and D, declining or terminating representation. A was violated when it became clear that respondent was not competent to handle the representation, yet he failed to withdraw. D was violated by the failure to keep accurate time records. 8.4 C and D, professional misconduct. C was violated by issuance of the $3,500 check with the knowingly false explanation that it was an arbitration award after having placed the funds in trust to cover the check just days before. D was violated by specific instances of conduct prejudicial to the administration of justice, including the deficiencies in filings noted by the U.S. District Court and Kansas Court of Appeals. In the Kansas Court of Appeals, there was a filing of 6 notices of appeal, only one of which went forward. Briefing that was convoluted and impossible to square with the record on appeal, and ignoring a Court of Appeals order to address jurisdiction in a brief, and then only briefly addressing it in a reply brief. Excuse me just a second. The disciplinary administrator recommended as discipline a 1-year suspension with a reinstatement hearing requirement, as well as a refund of the fees the complainants paid to the respondent, which were determined to be $46,910.
Let me ask you, Mr. Stratton, about your refund, or I guess it's akin to restitution, and that you determined that to be the 46,000 plus figure based upon a settlement offer that was made by the home builder of $75,000. Am I right there?
Justice Rosen, that was actually a calculation that was employed by the hearing panel. The hearing panel determined that the total amount paid to Mr. Borich by the complainants was the 46,910. They employed the 75,000 that they determined could have been achieved by settlement in determining the different amount of attorney fees, 21,900, that they determined should be the refund.
Okay, but so you're not using the 21,000 figure because that kind of didn't make much sense to me, just because a settlement offer was rejected by Mr. Borich's clients. Anyway, so your suggestion is that the fee that is due to the clients is $46,000 plus. Okay, thank you. No, okay, thank you. Okay.
The disciplinary administrator maintains the totality of respondents' misconduct warrants a 1-year suspension with reinstatement hearing. 3 findings are particularly troubling. Only one was cited in the KRPC HC violation, and that was the $3,500 check. The other 2 instances are respondents' demands for payments of $5,000 in February 2011 and then $500 in April 2013, both as shown on Exhibit 5, and each in addition to the regular $500 monthly payments. These payments were demanded and paid by the complainants. The demands for these payments were made despite the promise not to seek the additional fees that were in the promise made in the late 2008 amended fee agreement in Exhibit 4. And then in support of his request for the additional $5,000, the respondent told complainants that his timesheets showed the amount of time spent in the matter was almost incalculable. It was not until the complainants and then the disciplinary administrator asked respondent to provide his timesheets that he admitted there were no timesheets. At paragraph 21 of the final hearing report, the panel concludes that the statement that $5,000 more was needed was false. The disciplinary administrator suggests these 3 instances occurring over a course of years show a pattern of deceptive behavior on respondent's part. When that behavior is considered along with the other instances of misconduct, which show less intentionality but are still of concern, we contend that the recommended 1 year with reinstatement hearing should stand. It's needed to assure that the respondent will never again allow himself to stray from the path of proper conduct or allow himself to get into a position where he can cause harm to clients such as occurred in this case. Further to the issue of the $46,910, we would point to 228F. Rule 228F authorizes the appropriateness of the fee award to be taken up in this hearing because it's part of the recommended discipline. 225 provides authority for it as well. In Re Barker at 299 Kansas 158, a 2014 case, provides further authority for it, we would contend. Barker has a number of similarities to this case. One interesting dissimilarity. In Barker, the clients were not considered vulnerable, but in this case, they were considered determined to be vulnerable. In Barker, the clients were determined to be damaged by the lawyer's actions and inactions. Payment of those damages were made part of the discipline. They were ordered to be paid as a condition of reinstatement following 6-month suspension. Here it's the attorney's fees that are the subject of the discipline, and the panel has not made a requirement that they be repaid as a condition of reinstatement. I suggest there's no significant distinction between a payment obligation created by damages caused by the lawyer's actions and one consisting of a requirement for reimbursement of attorney's fees that grew and grew because of the lawyer's actions. In each instance, the harm that the lawyer caused cost the client's money, and that should be the deciding factor. Thank you.
Any questions? Thank you, Mr. Stratton. Mr. Ambrosio?
Madam Chief Justice, your honors, may it please the court. And Madam Chief Justice, with your permission, at the conclusion of my brief remarks, my client would like to address the court.
Certainly.
Let me start from the beginning. The facts, and I came into this case late. I didn't get into this case till after the formal complaint had been filed or until probable cause was filed. I'm not saying that that makes me such a bright star, but things may have been handled a little differently. And that's not to place discredit on his first lawyer. The facts and violations described by my colleague and also in the panel report are admitted, and we did not take exceptions. We believe that the court should discipline Mr. Borich in keeping with the panel recommendation of 90 days. And we believe that, and my client will accept that 90 days, and he also will agree to repay the 21,000 some odd money back to those individuals. And I'll get to that.
Yeah, Mr. Ambrosio, why don't you jump to that? Because I don't understand
to.
the $21,000 figure.
I
It's
think-
as if the hearing panel was saying that the original contract should be enforced, which was an agreement to accept 1/3 of whatever the settlement may or whatever, how this case would be resolved. And there was a $75,000 settlement offer, correct?
That
As
is
I
correct.
understand it. And so the hearing panel implies that then he was due $25,000 because his clients rejected that offer. And I don't see how that's complying with the contract. There was never any settlement reached. And why should that be even factored in and subtracting from the $46,000 that ultimately is owed? I don't understand that formula.
Justice Rosen, I understand the formula, and probably won't surprise you that I agree with the formula by the panel, how they arrived at it. I think that what the panel is saying, and again, I don't mean to speculate, but I'll do it anyway. They said exactly what you said. These people should have accepted the $75,000.
Well, why? Why? I mean, there was $290,000 at a minimum of what they thought the damages were, and they're to settle for $75,000. Isn't that within the purview of their clients and counsel to discuss that, even in spite of counsel's advice that they accepted? I don't understand why they should have accepted that. They didn't.
Well, clients a lot of times don't listen to their lawyers. I appreciate that. And clients many, many times are wrong, and they end up coming up with the empty sack because they did. He advised them to take the $70,000. They chose not to. I believe, and again, not the panel. I believe what the panel was saying is they should have accepted it. This was the tough case. It was an impossible case, and therefore he should only have to pay that money back, is what they're saying. And I don't apologize for the panel, Your Honor. I'm just saying I agree with them, and my client is willing to follow that. All right. Client, and this is the problem with this case from the beginning. Very few lawyers would have taken this case. The biggest problem I have found when I am representing lawyer clients is their inability to say, no, I don't want your case. Don't let the door hit you in the posterior on the way out. It is hard for many people to do that. It is impossible. Some of us are lucky and we're able to do that. My client, Mr. Borich, was unable to do it. He knew once he got into this case that he was in over his head. And I agree with my colleague, Mr. Stratton. He knew he was in over his head. At that point, he should have gotten out. He should have told him, I'm incompetent to handle this. I have an inability to handle this. I want out. And then this probably never would have happened. He was wrong in some of the things he did, and he accepts that. He was wrong to change the contingency fee contract without doing it in writing. He was wrong not to keep track of his hours. All of us keep track of our hours. But he was going through a 10-year battle on a case he should not have been involved in. He had a 10-year battle on a case where he had difficult clients, and I am not disparaging the clients, but there are difficult clients, there are impossible clients, and the best thing for us lawyers to do is to kick him to the side at that point. They could not have found another lawyer to represent on this case. Again, it does not excuse Mr. Borich's conduct during the course of this litigation. He had permission to bring the other lawyer in. At that point, he obviously knew he needed help and he was in dire need of help. He should have gotten out then, he didn't. Hence why my client is willing to accept the 90-day suspension. Hence why my client is willing to work to pay the money back to the client. And I'm going to advise you, he's not lucky like some of us. He doesn't have $21 or $40 or $100,000 in the bank. He is going to have to pay this money over time. And he has indicated to me that he is willing to pay back that money over time. It may be $1,000 here. It may be $2,000 here. It may be $1,500 here. And he's willing to do that. I think we have to look at the mitigating factors too. I'm representing a client who will be 73 years old in November. He's 2 years younger than me, and he has had basic problems. He's had a heart attack. He's had a stroke. He has had cancer. He has been hospitalized since the panel hearing. He has been unable to practice all the time, but he still wants to come stand up to the plate. I have a hard time understanding it. I think every day I want to get out of this. I want to stop this. God love him for wanting to continue and wanting to practice. He has a license in Missouri. He still has cases in Missouri. He has cut down on the amount of cases he has in his office. He has cut down on the type of cases he has in his office. He is willing to proceed to pay these people back, albeit it's going to take some time. I don't know why my client notified, by the way, his malpractice carrier. I don't know why these folks did not send a demand to the insurance carrier. I just don't understand. If they were so terribly wrong, they should have gotten a lawyer and filed a claim. I understand that makes no difference. If the ball is still in his court, but I wish to God that he had done that, because then they would have been made whole. Whatever Justice Rosen whole means. If it was a bad case, the insurance company would have paid. If it's as bad as I think it is, they wouldn't have paid. If he screwed up even a bad case, they would have paid something and these people would have been in better shape. I am urging you to follow the panel's recommendation, who dealt with my client with kindness. They dealt with my client with respect to his age. They dealt with the fact that he should not have gotten involved in this case. Without any further ado, I would like my client to address you, if that's okay.
It is. You may
Borich,
proceed.
please.
Is it my turn?
Yes.
It is.
So,
I don't know what to say, if it would help me or hurt me, but I have to speak from my heart. I've been an attorney. It'll be 49 years in September, and I'll actually be 74 in November. And, you know, it's been a privilege being an attorney all these years. And, you know, I in all that time, no disciplinary complaints, no fee disputes, no malpractice cases. And I carry malpractice, so if I do make a mistake, I cover someone, you know, with all those premiums I paid for all those years. You know, this word justice here. And I, you know, like going to the courthouses, meeting attorneys, meeting justices. And it's been a beautiful, beautiful experience. And I still encourage everyone that's young to consider law as a decree. You know, the only thing I could say on this Doherty case, I did the best I could with the skill set I had. That's it. I mean, I just did the best I can. I agree, maybe I should have terminated it and said, in spite of the criticism that came to me, that, you know, I thought I could still get the job done. I was wrong. I should have withdrawn, or they should have fired me, or they should bring a malpractice claim. I think it's barred time-wise. Why that never came, why a fee dispute case never came, I don't know. You know, I'm doing the best I can with that. So, you know, this is a very humbling experience. I know no one cares if it's a humbling experience. No one cares if it's an embarrassing experience for an attorney to go through this. You see your case on the court's marquee and you feel like a criminal. I feel like a criminal. And I see everyone frowning and I feel like a criminal. And, you know, maybe that's what I deserve, but I sure as heck have done the best I can with a smile on my face every single courthouse I have entered in my entire life. That's it.
Mr. Borich, may I ask a question?
Yes, ma'am.
First of all, please don't assume what we're thinking. I think we're all trying to concentrate and listen to what people are saying. I'm sure this is difficult. But my question has to do with the numbers that goes back to what Justice Rosen said. And is it possible that perhaps and maybe you would know from being there, that there's not a direct correlation or translation between what might have happened in the civil case that was pending and how those numbers are considered in conjunction with the disciplinary case and what appropriate sanction might be to you? Is that what is happening here on these numbers, and assessment of some responsibility to decrease what they think ought to be owed?
I mean, I guess I don't know enough about the disciplinary system because I haven't been in the disciplinary system, or is that part of my practice? So I'm not skirting the question. I'm in over my head to say, the issue of restitution or this or that, how they came up with the numbers. I honestly wish I could give you that answer, but I don't know. But they assume.
That's fair. Maybe it's a question I should ask Mr. Stratton.
Yeah, thank you.
Any other
And I
questions?
apologize to the court. I don't expect any smiles, but that's not a derogatory comment. I'm just, again, this is who I am and how I talk.
Anything further, Mr. Ambrosio?
I believe Mr. Stratton has some rebuttal time. And I have nothing further.
Okay. Mr. Stratton?
Thank you, Your Honor. I would suggest that the complainant should not be faulted for their decision not to accept $75,000 on the repair of the home. As I mentioned, it had extensive problems. That's Exhibit 45. CD, one of the clients, testified that there are explosions when the ground on which the home is built expands or contracts. As previously mentioned, Exhibit 46 shows repair estimates that are far greater than the $75,000, which was a conditional offer. It was I don't know how to describe it. They wanted the complainants to offer $75,000, which they then telegraphed they would accept. And of course, the plaintiffs were not willing to accept. In my view, it's wrong to blame the clients here, whether they turn down $75,000 or $300,000. You either see, yes.
Counsel, certainly in the civil case, the clients would have had the right and opportunity to turn down any offers and go to trial. But then it would be legal warfare, and they might not get anything, right?
Yes, and in fact, that is what happened.
So here the focus is on Mr. Borich, not necessarily on the clients. And the panel's going to have to make certain judgment calls and judgment decisions, because what they're thinking about is how much they believe Mr. Borich ought to pay at this point, right? And do you think, how did that translate from the civil case to the disciplinary case in looking at all of those numbers and including attorney fees?
Your Honor, it's a fair question, and I have trouble putting aside my advocate's hat to speculate what the hearing panel might have been considering. I believe that there's been an inordinate focus on the clients in this matter from the get-go. It happened with Mr. Borich's friend, Doug Patterson, when he responded to their request for an accounting. It happened at the hearing and opening statement when the clients were disparaged. It's happened today when the clients were called difficult or impossible. And I just think that's wrong. the clients have contributed so much to this effort. They drafted dozens of pleadings, CD did over the course of years, prepared questions for respondent to ask. JD, CD's husband, said he furnished citations for inclusion in the pleadings, assembled exhibit books, delivered them to the court and counsel. CD's, we've heard reasons to feel sympathy for Mr. Borich, and I certainly don't want to suggest that I lack sympathy. I have sympathy for Mr. Borich, but there should also be sympathy here for the clients. CD is a disabled veteran whose health was deteriorating. She had a heart attack. Neither could step back from the work, even though they tried, because in JD's words, the case needed to survive.
Excuse
yes.
me, clarify for me what you think an appropriate restitution amount, because I'm a little confused. I've got a $46,910 figure and a $21,900 figure. And I don't understand. Do you want us to add those two figures, or is the
Oh, no.
just
No, we're asking for the 46,000 figure to be ordered, to be repaid to the clients.
Other questions? Anything further, Mr. Stratton?
I could cite further to the record regarding the extent of work that the complainants performed, particularly CD, and under what conditions. One more fact that I thought was significant was that she testified that at times when Mr. Borich would come to their house to review the pleadings that she prepared, he would get curt with her, get angry with her, and she would have to respond to him. On other occasions, he fell asleep while there to review the pleadings. She testified to that at page 100 in the transcript, and complainant pretty much admitted it at page 165. I think that there is a place for sympathy. I also think that the purpose for this proceeding is to, in the end, to protect the clients, and that's what I'm seeking here.
Any other questions? Thank you to all of you for your arguments and statements in this matter. The court will take this under advisement. We are